wreck occurred on a big turn in Canyon Road, true?
Very, very dangerous stretch of road.
That's right. You've actually driven that stretch of road several times.
Yes, sir.
You know that there's no guardrails that extend all the way through the turn.
Of course.
You know that there are no streetlights there.
It's very dark.
You know that it's a heavily wooded area.
Correct?
In fact, you had a conversation with the defendant prior to the night of September 24th about Canyon Road, true?
Yes, Danny knew about the road as well.
In fact, you told the defendant that several people had died there because they were speeding.
Yes.
You told the defendant that it was a dangerous road.
Yes, Danny was already aware of that.
And when you read about this crash in the paper, you'd say it was no surprise that he ran off the road if he was speeding.
There are a lot of factors involved, but speed was likely one.
Is that a yes? It wasn't a surprise to you when you found out he ran off the road?
Surprise or not?
Yes or no, you would say that it was no surprise that he ran off the road.
No.
You remember preparing a signed and sworn statement?
Well, I'll admit that is no, it's not a surprise.
That's right, because you could have anticipated that if he was speeding in the rain, that this would have happened.
Correct.
Now, on the night of...
Speculation.
I tend to agree. Does he know that Danny was speeding in the rain?
Well, he just stated that he did.
Did you, or did you?
Your Honor, he read about it in the papers, we already
Right.
established. He read that it was raining. We can actually lay a foundation that he's aware of the time the accident occurred and the weather conditions at that time. And as he previously stated, he is aware that the defendant was speeding.
How is he aware of that?
He read it in the paper.
And you would change your objection to hearsay?
Oh, hearsay.
Without offering for the truth that he was actually speeding, only to go to this witnesses or the effect on the reader in this case, specifically as to whether or not he concluded that he would have anticipated the driver going off the road if he was speeding.
Right. If you were clear in your questioning to make sure that you phrase it that way, not to make it a statement that he was speeding, then I will allow the testimony. Make sure that the witness does so, and feel free to review your objection.
You would agree that on the morning of September 25th, if the defendant was speeding in the rain, you could have anticipated that he would have run off the road, correct?
Under the
Objection,
totality
Your Honor,
of
I
the
still feel that the
circumstances.
question asks for cause for speculation.
Rephrase your question, repeat your question one more time so I can listen to it.
If the defendant was speeding in the rain on the morning of September 25th, you have stated that you would have anticipated that he ran off the road.
I would say that is he giving an opinion?
I would say also in proper opinion.
Is it relevant what he thinks?
Your Honor, this witness already said it was no surprise he ran off the road. We'll move on.
Yeah. Is there more line of question? What I'm trying to do is not cut you off if you have more questions that follow, because I want to give you a chance to go through your entire cross.
There's plenty more questions. We'll just keep moving.
Let's move on.
Everyone now?
Since he is strictly asking for this witness's opinion, not stating that the defendant was speeding, I will allow the testimony.
So yes, you could have anticipated he would run off the road.
Under the circumstances present, yes.
Now, you read that the crash occurred at 1 a.m., true?
Roughly, yes.
And you were aware that 1 a.m., the morning of September 25th, it was raining very heavily.
Yes, very much so.
In fact, there was a flash flood warning in Midlands, true?
I've read that in the paper, yes.
And you stated the defendant walked to the parking lot at 12:40 a.m. the night of September 25th, correct?
Correct.
Now, the defendant did not ask you for a ride, did he?
He did not at the point in time, said I drive too slow. Again, part of his joking demeanor.
In fact, you had to flag him down and ask him to get your cab,
Yes.
correct?
Yes.
Now, earlier you stated that the sentences he put together were well structured, and that's why you didn't think he was drunk, correct?
Correct.
Isn't it true that he actually only stated less than 10 words to you?
Correct, but his posture and tone were that were well structured.
Now, just to be clear, the defendant made the decision to refuse this cab ride, correct?
Yes, he did.
He's the only one who stated that he was not going to get in the cab.
Correct.
Neither Taylor Hobson nor Vanessa Sullivan spoke a word to you.
Not that I recall.
And as the defendant walked away, you let him go.
Yes, I did.
And that's because you thought Vanessa Sullivan was going to be the one driving.
Yes and no.
Isn't it true that you thought Vanessa Sullivan was going to be the one driving?
Yes.
But as they got to the car, you saw the defendant open the car door,
Correct.
get behind the wheel,
Correct.
and as he pulled out of the parking lot, he actually burned out.
The tires did screech, but the pavement was of course wet.
And he fishtailed and swerved as he left the parking lot.
Again, a result likely of the wet pavement.
Now, just to be clear, you said the defendant was or did not seem intoxicated when he left, correct?
In fact, the exact opposite.
At 12:40 p.m.
Correct.
a.m. Right. At 11:20 p.m., the last time you interacted before he left, you actually spoke with the defendant, correct?
Correct.
About an hour and a half before he got behind the wheel.
Yes.
About an hour and a half before he got behind the wheel, he was slurring his words.
Yes.
About an hour and a half before he got behind the wheel, he was stumbling as he walked.
Mildly.
About an hour and a half before he got behind the wheel, you would say he appeared drunk.
Somewhat, yes.
About an hour and a half before he got behind the wheel, you would say there's no way he should have driven that night.
Correct.
Thank you. Nothing further.
Any reasons for that?
Yeah. Mr. Long, again, you saw Dave Dawson leave Checkers that night.
Correct.
Did you notice him slurring his words?
When he left the bar that night at around 12:40 a.m., no.
Did you notice him stumbling at the time he left the bar?
No, not at all.
Did he appear intoxicated to you when he left Checkers bar and got into the car?
No, if he did, I would not let him drive.
Thank you, Brian.
Mr. Mays?
Yes, sir. I just have a few. Kind of the same comments as far as the last direct. We need to have some kind of character for the witness. Got to work on that. I'd say it's not a prior character trait because it happened that night. That would be an argument. He's responsible. That came out during this during this direct. I probably killed that on cross-examination. Gray did a good job of killing anyway, but I probably would have used that to a greater extent. Cross-examination, you can't ask the attorney questions. I wouldn't do that. You could say, I don't understand the question or something to that effect, but I wouldn't ask the attorney questions. Grady, I'd say, very good cross, but came on just a little bit too strong, a little too soon. Let him be the jerk first, and then you can come and pounce on him. Or let him be evasive or something first. Don't fold your arms. This demeanor here kind of indicates I'm kind of being closed off. So everybody, don't fold your arms. It goes for witnesses and attorneys. The joking demeanor phrase kind of got a little old. I would say something more to the effect of, well, you got to know Danny. He's I don't know what would be a better phrase than that. I don't know. The joking demeanor got kind of old.
Well, yeah, it's good the first time.
Yeah. Very good job for Grady. About an hour and a half before he got behind the wheel, and you tack on all the phrases. Ken, what I would have done on redirect was, at the time, right before he got behind the wheel,
And
you would
ask every
say,
single
and ask
one.
the same
Every
thing
single one.
that Grady did, and then sit down.
Or I would have considered an hour and a half later, did he, an hour and a half later, did he, and asked every single one question. And I don't know how that sways. Some jury members would say an hour and a half is plenty of time to sober up, and some would say it's not, so.
Well, it
I
also
could go-
depends on the thing that I never really asked. An hour and a half may be enough time to sober up, but after you've been drinking for 9 hours,
Yeah, seriously.
Right, so that you don't lose a little bit of credibility, when she's asking about, do you know Danny? Yeah, you know him, you know, your acquaintances and stuff, but I wouldn't go so far as to say he's a very good friend of mine, because that would be somebody you would want to help out, you know, but if you kind of distance yourself a little bit, you know, it makes it look like you're not trying to help your buddy out. Y'all have an odd, non-responsive answer in the middle of your direct. You asked the question, did you recognize the two friends at the table? And he said, yes, I recognized them. One was Taylor Hobson, and I kept waiting for the and, or whatever. And then you immediately asked about Taylor Hobson and never circled back to the other one. So, you know, say, yeah, I recognize them. One was Taylor Hobson and one was Vanessa. And then go into your question about, well, let's talk about Taylor. Do you know Taylor? For the character of the witness, yeah, we gotta, you know, figure out something. A suit is always appropriate for court, but I don't know, you know, we could do something with not dressing up so much since it is a cab driver. I don't know, we'll figure something out. All right, other than that, Corey?
Yeah, agreed on the character thing. I like the bow tie. I could see a third shift cab driver wearing it. I don't know why.
Yeah, I agree.
Yeah.
That does add character.
But we need to do something because we have a mass amount of potential to make this like hysterical. You know, some like crazy man with like cross-eyed, you know, look, he's got like an accent or something. But I put in my notes C. Francis Gustavo. Your captains will know what I'm talking about. But that would be a tremendous example for you to go by. But I mean, you can be as creative as you want. And I'll kind of point out Valencia. Everyone thought, you know, oh my God, she's over the top. A lot of people think that, you know, if they do or say something characteristically in a mock trial witness persona, it's going to be over the top. But when in doubt, go over the top because chances are it's not. You have a lot of freedom with how you portray this character. So just be thinking on that. Let's see. Oh, Kim, your last question is something to the effect that did Danny Dawson appear intoxicated? That might be objectionable. It depends on the judge and the way you ask it and the way he answers. You say, in my opinion, something. Either have a great argument ready to keep it in so you can ask it again, or have a parachute question so you can fall back on that.
I'd have the parachute question anyway.
Yeah.
Though I think your argument is he's a cab driver, he's seen people who are drunk before. Certainly he's got the prior knowledge, and under Rule 701, this is based on his rational perception.
Yeah. On the cross, I'll make two examples out of Grady, what things not to do. I mean, it was a good cross, yeah, you all know that. But he, and I think kind of everyone's been doing this, and maybe I wasn't paying attention in pretrial, but everyone's kind of been asking permission before they do anything, and I don't think he wanted permission from anyone to do anything except like, what, approach the witness? Or?
Yeah, that was it.
Okay, yeah, just be mindful of that in pretrial, because every judge is going to have different expectations, and especially law student judges, they're always going to be watching, make sure you're paying attention to those, and if you're not, they're like, they get so pissed. I don't know why, it's just a law student thing. And another thing that Grady did, he asked the impeach question again, I think because he knew he could get by with it. Never do that. Goes for all attorneys who are in here. Once you impeach a witness, don't ask that question again. The jury or judges, for all purposes, have already seen that the witness has contradicted himself. You move right on along and you don't ask it again, because that just gives them one more chance to explain it away, and you never want to give them that. Yeah, and I thought the redirect was also helpful because he ended with his hour and a half stuff, and then you know, right back up again. Like, okay, well, right before you left.
But it helps to have the same rhythm as he had.
Yeah. Yeah.
Couldn't remember.
Yeah, that's all I got for.
And this is a side note, and for all the witnesses, because all these comments seem to be for attorneys. If you have a set of lines in your affidavit that you know they can hit one after the other, like he was stumbling, he had slurred speech, he appeared intoxicated, whatever, you can cut the attorney off. Let him ask that first one, and then if he goes into the second one, just go ahead and say, yeah, when I saw him in the bathroom, he was stumbling, and go ahead and name the other ones, and he had slurred speech, and he did appear intoxicated at that point, because then he can't ask them, and if he does, they can object and say, asked and answered.
And it,
or cumulative.
and it throws the attorney off his game. It'll make them like stumble and like, you know, falter a little bit. It works
So
all the
if
time.
you know as a witness, you're gonna get hit with a line of, you know, 3 or 4 questions in a row, you know, don't give it away if they don't go into it. But if they start down that road, give them all of them, and then, you know, they can't hit you 3 times, they only hit you that once. All right, defense have any other witnesses?
Yes, sir. We call Leslie Roman.
All right, Mr. or Ms. Roman?
May I proceed?
You may.
Can you please introduce yourself to the court?
Yes, my name is Leslie Roman.
What do you do for a living?
I'm an accident reconstruction expert.
What does that job entail?
I'm hired by private parties to simulate car crashes.
What are your qualifications?
I graduated with a degree in mechanical engineering from the University of Texas in Austin. I also worked for 5 years at the Midlands Department of Transportation as a traffic engineer. For 5 more years, I worked at Global Motors Manufacturing Corporation, and I've also received certifications and taken courses dealing with accident reconstruction.
Where do you work now?
I own my own accident reconstruction firm, Expert Accident Reconstruction Inc.
What rate do you charge to be involved in this case?
I have a standard rate of $200 an hour, but I'm getting paid an additional flat fee of $2,000 since I'm testifying at this trial.
Is this a standard rate in your field?
Yes, it is.
How did you become involved in this case?
I was hired by the defense to recreate the car crash that happened on September 25th, 2010.
What materials did you use to do this?
Naturally, I examined the car itself, as well as the police report and the police photos of the crash. I also reviewed the statements of London Bennett, Taylor Hobson, and David Dawson.
Did you use standard methods and procedures when evaluating this crash?
Yes,
Did you have sufficient data and information when evaluating this crash?
yes, I did.
Did you apply the methods and procedures to the information and data?
Yes, I did.
What were your findings?
I found that the car was traveling northbound at around 51 miles per hour, and the car exited the road on the right-hand side, and then the driver tried to re-enter the road, but overcorrected, and the car rotated counterclockwise and exited the road again on the left-hand side.
Did you author a report regarding these findings?
Yes, I did.
Your Honor, after approaching the opposing counsel bench, can I approach the witness? I am showing the opposing counsel what has been pre-marked as Defense Exhibit A. What is this?
This is the report that I created concerning this case.
Is this a fair and accurate copy?
Yes, it is.
Has it been tampered with or modified in any way?
No, it has not.
Do you make these sorts of reports as part of your regular business practice?
Yes, I make one for every case that I investigate.
Do you make this, did you make this business record?
Yes, I did.
Did you keep this business record?
Yes, I did.
Are you the custodian of this business record?
Yes, I am.
Did you make this business record at or near the time of your evaluation of the crash?
Yes, I did.
Your Honor, at this time, I want to introduce into evidence, I move to introduce into evidence what has been pre-marked as Defense Exhibit A.
Any objections?
No objections, Your
All right, it is admitted.
Now, you stated in your report and in what you've just said that Mr. Dawson, driving the car, first exited the road on the right-hand side. Can you tell us how you came to that conclusion?
Yes, there, on the right-hand side of the road, there's rutting that indicates a car exiting the road and leaving marks there.
You also stated in your report and in your testimony today that Mr. Dawson then re-entered the road and exited it on the left-hand side. Can you tell us how you arrived at that conclusion?
Yes, the rutting continues then on the left-hand side of the road, 144 feet after it ends on the right-hand side of the road.
Why did Mr. Dawson exit the road in the first place?
According to his statement, he exited the road to...
Objection, speculation?
I would tend to agree. Your response?
Your Honor, the witness used the affidavits, as she said, of Mr. Dawson, to which point this is not speculation, but this is what the defendant has told her he saw. So it's not speculative, she's using evidence that is otherwise, that may not be admissible in court, but is otherwise admissible to demonstrate to this court how the expert witness arrived at her conclusions.
All right, two things. First of all, just because a defendant says it happened, does that make it true?
No, but it doesn't make it speculative.
All right. Second of all, you are correct in that a person, an expert witness, can use inadmissible material to come to their conclusion. However, she can give that conclusion in the form of an opinion, not in a statement of fact. Do you have any response?
Only that she cannot say conclusively whether or not a deer was in fact on the road.
That's exactly right. She can give her opinion as to why, but she can't say that that is indeed what happened. She can just tell her opinion, and it's up to the jury to determine why, or what actually happened. So, your objection is sustained. Do you have a motion?
Motion to strike the
I
testimony.
will strike the testimony, re-ask the question, but get her to give an opinion, not a fact.
In your expert opinion, why did Mr. Dawson leave the road?
Danny Dawson left the road to avoid a deer that jumped out into the roadway.
In your investigation, did you find any evidence to contradict Mr. Dawson's statement?
No, I did not. In fact, there is a deer crossing sign a mile south of where the crash occurred.
Your Honor, after I approach the bench of opposing counsel, may I approach the witness? I am showing opposing counsel what has been pre-marked as Defense Exhibit B. What is this?
This is the picture I took of the deer crossing sign on Canyon Road.
Is this a fair and accurate representation of the deer crossing sign?
It is, yes.
Has it been tampered with or modified in any way?
No.
Your Honor, at this time, I move to introduce into evidence what has been pre-marked as Defense Exhibit B.
Any objections?
Relevance?